You know how sometimes things look calm on the surface, but underneath there's just a whole lot going on?
Hmm.
That's kind of how India's constitutional scene feels right now. It's like we're watching this political drama unfold.
Yeah.
You've got the Supreme Court making big moves, Vice President Dhankar pushing back pretty hard, and well, the whole situation down in Tamil Nadu is right in the middle of it all.
Absolutely. And it's more than just political jostling, isn't it? It really gets to the heart of how democracy is supposed to work.
How it functions day to day.
Right. You're seeing this tension, this friction between different parts of the government, the courts, the executive, the legislature, and how they each see their own roles. It's not just dry law, it's the Constitution in action.
Exactly. It sounds maybe a bit abstract, but it actually has real consequences for how laws get passed, how the country runs. So look, our aim today in this deep dive is really to try and unpack all of this.
Cut through the noise a bit.
Yeah, highlight what's really significant and just give you a clearer picture. We've been looking at a lot of the recent reports to kind of piece together this developing story.
Okay, so maybe the place to start is that big Supreme Court ruling back on April 8th. That seems to be the catalyst for a lot of the recent back and forth.
Yeah, Justices Pardiwala and Mahadevan. And it wasn't just a suggestion, was it? It felt like a pretty firm line in the sand.
It really was. They
Yeah.
basically put a clock on things. They said the president and also state governors, they have 3 months. 3 months to act on bills sent to them for approval.
So no more just letting bills sit there indefinitely, like a deadline.
Exactly. And the crucial bit is what happens if they don't act within those 3 months. The court was clear. Those bills could then face legal challenges.
Okay.
And, maybe even more significantly, they said that even the president's decisions on these bills could potentially be looked at by the court's judicial review under Article 201.
Wow. Article 201, that's the one about the president's options for state bills assent, withhold, or return?
That's the one. So the court is essentially saying, our oversight might extend even here, which is, quite a statement.
And that immediately makes you think of Tamil Nadu, doesn't it? Because this wasn't just happening in a vacuum. This ruling landed right in the middle of an ongoing standoff there.
Precisely. It's directly linked. If you rewind a bit, between 2020 and 2023, the Tamil Nadu legislature passed, I think, 13 bills? Quite a few.
Yeah.
But 10 of those hit a roadblock with the governor at the time, R.N. Ravi. He either sent them back or, well, just didn't act on them. Sat on them, basically.
Right. And then the state legislature, led by Chief Minister M.K. Stalin's DMK party, they did what legislatures, they repassed those same 10 bills.
Mm-hmm. The usual expectation then is, okay, now they get assent.
Yeah. But Governor Ravi took a different path. He sent them upstairs, forwarded them to the president instead.
And that's when the Supreme Court really stepped in, responding to the state government bringing the issue to them.
And their reaction was strong, wasn't it? They didn't just disagree politely.
No, not at all. They called the governor's delay, that initial inaction, illegal and arbitrary.
Yeah.
And those are powerful words coming from the highest court.
Very strong. But they didn't stop at just words. They did something pretty extraordinary with Article 142.
Ah, yes, Article 142. Their special power, you could say.
They basically said, okay, these 10 repassed bills, they're law now. And they backdated it to November 18th, 2023. No governor's signature, no president's signature needed, just law.
It's unprecedented, really. Invoking Article 142 to bypass both the governor and the president and declare state legislation as law, it really shows how seriously the court viewed the governor's actions.
And you can imagine the reaction. Opposition parties were quick to call it a huge win for federalism, right? Strengthening the state's power.
Definitely. They saw it as pushing back against potential central overreach via the governor's office.
Yep.
But on the flip side, we heard reports that the central government wasn't too pleased and might be thinking about asking the court to reconsider a review petition.
Which perfectly sets the stage for Vice President Dhankar's response just over a week later, April 17th. He had a very different take.
A very different take. He was speaking to some Rajya Sabha interns, I believe, in New Delhi.
And he didn't mince words either, did he? He used some pretty intense language.
Intense is one word for it. Describing Article 142, the very power the court just used, as a nuclear missile against democratic forces available to the judiciary 24/7.
Wow, a nuclear missile.
Listen,
That paints a picture. It clearly signals he thinks the court went way too far.
absolutely. He basically accused the court of acting like a super parliament. stepping outside its constitutional lane and into the territory of the legislature and the executive.
Yeah, and a big part of his criticism was aimed squarely at that 3-month deadline the court set for the president.
Right. He argued the president is the highest constitutional authority. The idea that the judiciary could impose a timeline on the president, he clearly felt that was crossing a line.
He brought up the president's oath, didn't he? To preserve, protect, and defend the Constitution. His point seemed to be that the president needs the freedom to do that properly without the court breathing down their neck with a stopwatch.
Exactly. And he also talked about the judiciary's specific role, pointing to Article 145.3.
Okay, what's that one about?
That deals with how the court interprets the Constitution, or substantial questions of law. It usually requires a larger bench, at least 5 judges. Dhankar's argument seemed to be that interpreting law is one thing, but directing the president on timelines, that's something else entirely, and maybe not within their remit, especially for a smaller bench.
So this really throws Article 142 itself into the spotlight. I mean, what exactly is this power that the court used?
It's quite unique. Article 142 basically gives the Supreme Court very broad power to pass any order it thinks is needed to ensure complete justice in a case before it.
Complete justice. That sounds very wide-ranging.
It is. It's not strictly bound by existing laws, which gives the court flexibility in, let's say, unusual situations where the normal rules might not be enough.
And it's not the first time they've used it, right? It comes up in different contexts.
Oh, definitely. It's been used for environmental orders, like cleaning up rivers. It's been used in family law, sometimes to grant divorces where the marriage has completely broken down, even if the specific law didn't quite cover it. So its scope is pretty broad.
But that's exactly Dhankar's worry, isn't it? He sees this broad power, especially used like it was in the Tamil Nadu case and with the presidential timeline, as being like a blank check for the court.
Yeah, that's his fear, that it allows the judiciary to step into areas that belong to the other branches, blurring those crucial lines of separation of powers. He sees the Tamil Nadu ruling as a prime example of judicial overreach.
But the court probably sees it very differently. From their perspective, maybe it's about accountability. Stopping elected legislatures from being, blocked indefinitely by governors who aren't elected.
That's almost certainly the counter-argument. The court would likely say its intervention was necessary precisely to uphold the democratic process, to prevent the will of the people, expressed through their state legislature, from being nullified by inaction.
And it tackles that whole pocket veto problem head-on, doesn't it, where a bill just dies because no one acts on it.
Exactly. The 3-month deadline is a direct attempt to prevent that. It forces a decision yes, no, or send it back, but it doesn't allow indefinite delay to become a veto in itself.
Okay, so we have this major constitutional debate raging, but then Vice President Dhankar brought up something else entirely, didn't he? Something involving a judge.
Yes, he shifted gears a bit, but clearly linked it to broader issues of accountability. He talked about an incident back on March 14th. There was a fire at the Delhi residence of a high court judge, Justice Yashwant Varma.
Right, I remember hearing about that, and the allegation was that burnt cash was found.
A significant amount, allegedly. And Dhankar really honed in on how this was being handled. His main point: no FIR, no first information report was filed.
Which is usually the first step in any police investigation, especially involving potential unexplained money.
Precisely. He questioned why the standard legal process seemed to be bypassed. He even made some pointed sarcastic remarks.
Yeah, suggesting things would move a lot faster if it happened to, say, him or an ordinary person.
Exactly. A clear jab at what he saw as maybe preferential treatment or a lack of urgency. His core issue was with the Supreme Court ordering an internal probe by a committee of 3 judges.
Why was that a problem for him?
He argued that investigating potential wrongdoing, especially something potentially criminal like large amounts of unexplained cash, is primarily an executive function, something for the police or investigative agencies, not a judicial committee.
He felt the judiciary was investigating itself, essentially.
Sort of, and he questioned the effectiveness. He pointed out that a judicial committee can really only make recommendations. It doesn't have the power to, say, prosecute or discipline in the same way. He contrasted it with the actual constitutional way to remove a judge impeachment by Parliament.
A much more formal and separate process.
Right. And he called very explicitly for transparency, talking about exposing any skeletons for a cleansing of the system. He wants accountability across the board, including within the judiciary itself.
Which inevitably raises those really tricky questions about judicial accountability versus judicial independence. It's a tough
It's
balance.
a very delicate balance. You need judges to be independent to make impartial decisions, but you also need mechanisms to ensure they are accountable if allegations of serious misconduct arise. This incident and Thankar's comments really brought that tension to the surface.
So when you pull back and look at all these threads, the court's ruling on bill deadlines, Dunker's fierce reaction, the Tamil Nadu backstory, the power of Article 142, this whole incident with the judge, it all seems to circle back to that fundamental principle, doesn't it? Separation of powers.
Absolutely. That's the bedrock. Legislature makes laws, executive implements them, judiciary interprets them, each with its own role, its own sphere.
And Dunker's recurring point was about accountability. He kept stressing that the executive, the government, is accountable to the people through elections. Whereas the judiciary, while independent, doesn't have that same direct democratic check.
And his concern, his argument is, what happens if the lines blur too much? If the judiciary starts taking on roles that belong to the executive or legislature, like setting deadlines for the president or effectively making law retroactively, who holds them accountable for the consequences of those actions?
It's a fair question. But then the other side argues that sometimes the courts have to step in, right? When there are systemic problems, or when other branches are seen to be failing in their duty or even undermining the democratic process itself.
That's the justification you'd likely hear from the judicial perspective, that their actions, even if they seem to push boundaries, are ultimately about upholding the Constitution, protecting fundamental rights, and ensuring the whole system doesn't grind to a halt due to inaction or overreach elsewhere.
So it really is this constant kind of delicate dance, isn't it? Trying to maintain balance between these three massive pillars of democracy.
It's a perpetual balancing act.
Yep.
And what's striking about this moment is how public and, frankly, how sharp the disagreements are about where that balance should lie.
Okay, so as we sort of wrap up this deep dive, what are the key things for people to take away from all this complexity?
Well, I think first, there's the Supreme Court's big move on setting deadlines for bills, a real attempt to tackle delays.
Yeah. Then you have Vice President Dhankhar's very strong pushback, raising serious questions about judicial overreach, Article 142, and even judicial accountability with that judge incident.
Right. And all of this is playing out against that specific backdrop of Tamil Nadu, which really brought the issue of governors' powers versus state legislatures to a head.
And underlying it all is that debate about Article 142, is it a tool for justice or a blank check? And the unresolved questions around that cash discovery.
And look, why should you, listening, care about all this? Because this interplay, this tension, directly impacts how effectively our democracy works.
Yeah, it's about efficiency, accountability.
Exactly. When branches of government disagree fundamentally on their roles, or when accountability questions pop up, it affects everything: how laws are made, how government functions, ultimately the services and rights that affect everyday life.
It definitely leaves you thinking about the bigger picture, the long-term health of the system. What does it really signify for Indian democracy when these core pillars interpret their powers and responsibilities so differently?
That's the big question, isn't it? How do you best balance independence and accountability in a democracy? There are no easy answers.